To inform that Honorable Chief Guest and other dignitaries on way to this hall, and they are expected to arrive within 10 minutes. Thank you. Honorable Chief Guest has arrived. Honorable dignitaries have arrived. I most humbly seek the permission of Honorable Chair to commence the proceedings. May I, Lordship? Thank you, my Lord. His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairperson NALSA, His Lordship, Honorable Mr. Justice Sanjiv Khanna, Judge Supreme Court of India, His Lordship, Honorable Mr. Justice Rajesh Bindal, Chief Justice, Allahabad High Court, His Lordship, Honorable Mr. Justice Pritinker Diwaker, Judge, Allahabad High Court and Executive Chairperson, UPSLSA, His Lordship, Honorable Mr. Justice Manoj Misra, Judge, Allahabad High Court and Chairman, HCLSC Allahabad, Honorable Judges of Allahabad High Court, present as special invitees, all the Honorable Judges from 11 states participating in this regional conference, respected Member Secretary NALSA, and respected Member Secretaries of SLSAs, distinguished guests and other invitees, members of print and electronic media, respected members of Registry of Honorable Allahabad High Court, ladies and gentlemen, I welcome you all in this inaugural session of North Zone Regional Conference on enhancing access to justice in the spiritual capital of India, that is Varanasi. Lighting of lamp symbolizes not only brightness, but wisdom, knowledge, and enlightenment. And we begin our programs in the name of God with lighting of lamp. For this, may I very humbly request honorable dignitaries on dais to kindly light the lamp and formally inaugurate the program. O Lord, keep me not in unreality, but make me go towards the reality. Keep me not in darkness of ignorance, but let me go towards the light of knowledge. Keep me not in the sphere of mortality, but make me go towards the world of immorality and self-realization. Let there be peace all around on earth. As a mark of respect and sincere admiration, may I now request Honorable Mrs. Justice Sabina, Executive Chairperson. But before I request Her Lordship, Her Ladyship, it is my pleasure to announce that Honorable Mrs. Justice Sabina, Executive Chairperson, Himachal SLSA, has been appointed Acting Chief Justice of Himachal Pradesh, and the notification has to take effect from today itself, and it is a beautiful coincidence. We take this opportunity to congratulate Her Ladyship for being appointed as Acting Chief Justice. May I now request Her Ladyship to kindly present a live plant to Honorable Chief Guest, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, and presenting a shawl to His Lordship. May I now respectfully request Honorable Mr. Justice Manmohan, Chairman, HCLSC, Delhi, to kindly welcome Honorable Mr. Justice Sanjiv Khanna, Judge Supreme Court of India, by presenting a live plant and Angvastra. May I now very humbly request Honorable Mr. Justice Rajiv Shakdher, Judge, Delhi High Court, to welcome Honorable Mr. Justice Rajesh Bindal, Chief Justice, Allahabad High Court, by presenting a live plant and presenting the shawl. Thank you, my lord. May I now very humbly request Honorable Mr. Justice Augustine George Masih, Executive Chairman, Haryana State Legal Services Authority, to kindly welcome Honorable Mr. Justice Pritinker Diwaker, Judge, Allahabad High Court, by presenting a live plant and a shawl. May I now very humbly request Honorable Mr. Justice Sanjay Kumar Misra, Executive Chairman, Uttarakhand SLSA, to kindly present a live plant to Honorable Mr. Justice Manoj Misra, Judge, Allahabad High Court, by presenting a live plant and Angvastra. Thank you, my lords, for doing the honors. a system of justice delivery which is within the reach of everyone, including the poor and the marginalized sections of society, is a pious objective of NALSA. Today's conference is an important step to renew our pledge towards our duties and responsibilities in this regard. With these words, may I most humbly request Honorable Mr. Justice Pritinker Diwaker, Judge Allahabad High Court and Chairman, Executive Chairman, UPSLSA, to kindly welcome the guests.
My Lord, Honorable Justice Sanjay Kishan Kaul, Senior Judge Supreme Court of India and Executive Chairman, National Legal Service Authority. My Lord, Honorable Shri Justice Sanjiv Khanna ji, Judge Supreme Court of India. Honorable Justice Shri Rajesh Bindal ji, Chief Justice of Allahabad High Court and Patron-in-Chief, Uttar Pradesh State Legal Service Authority. Honorable Shri Justice Manoj Misra ji, Judge Allahabad High Court and Chairman, High Court Legal Service Committee. Honorable Justice Shri Ramesh Sinha ji, Senior Judge Allahabad High Court, Lucknow Bench and Chairman, High Court Legal Service Subcommittee, Lucknow Bench. My sister and brother judges of the participating High Courts, Member Secretaries of State Legal Service Authorities, the other members of NALSA family. A very good morning to all of you. On this memorable day, it is my privilege to extend a cordial welcome to all of you on behalf of Allahabad High Court and Uttar Pradesh Legal Service Authority at the bank of Holy River of Ganges. We are highly thankful to NALSA for giving us this opportunity to hold conference in the state of Uttar Pradesh. It gives me colossal desires to present a welcome note on the eve of inauguration of this one-day North Zone Regional Conference on enhancing enhancing access to justice at Varanasi, a place of rich heritage and pilgrimage. Varanasi or Banaras, also known as Kashi, is one of the oldest living cities in the world. This event is glorified by the august presence of Honorable Justice Shri Sanjay Kishan Kaul, Judge, Supreme Court of India, and the Executive Chairman, NALSA. And I sincerely trust and believe that upshot of this meet will certainly be benefited for the society. Though my Lord Justice Sanjay Kishan Kaul needs no formal introduction, it is my forever to introduce his personality to the distinguished dignitaries present here to take inspiration from his Lordship and the significant role being played in the Indian judiciary. My Lord Justice Kaul, a native of Srinagar, was born on 26 December 1958. His Lordship studied in Modern School, New Delhi till 76, graduated in Economics Honours from St. Stephen's College, Delhi in 1979, obtained his LLB degree from the Campus Law Center, Delhi University in 1982 and enrolled as advocate with Bar Council of Delhi on July 15, 1982. My Lord practiced mainly in the commercial, civil, writ, original and company jurisdiction of the High Court of Delhi and the Supreme Court of India. His Lordship remained advocate on record of the Supreme Court of India from 1987 till 1999 and was then designated as senior advocate in December 1999. My Lord was appointed as senior counsel for the Delhi High Court and for the Delhi University, was on the senior panel of Union of India and also served as the additional senior standing counsel for the Delhi Development Authority. His Lordship was appointed as permanent judge of Delhi High Court on May 2, 2003 and was also served as acting Chief Justice of Delhi High Court. His Lordship was then elevated as the Chief Justice of Punjab and Haryana High Court with effect from 1/6/2013 and the Chief Justice of Madras High Court on 26/7/2014, where he faced numerous serious problems but with his administrative skills handled all adverse situations in a most decent and effective manner. Considering my Lord's ability, he was appointed as Judge of Supreme Court of India on 17 to 2017. His Lordship belongs to an educated and renowned family of Kashmir, which has legal and political background. During his tenure as High Court Judge and also as Judge Supreme Court, my Lord has delivered several landmark judgments, but due to time constraint, I am not referring to all those judgments. However, a few of them requires to be referred. In 2008, His Lordship has decided a famous case in relation to the charges levelled against M.F. Hussain for his painting of a lady later termed as Bharat Mata, accusing him of obscenity. In 2007, His Lordship, along with 8 judges, ruled in favor of privacy being a fundamental right, which is a watershed moment in the history of constitutional jurisprudence of India. Recently, in Saudan Singh versus State of Uttar Pradesh, my Lord, having considered the long pendency of criminal appeals in the High Court, called upon the High Courts and the state government to prepare a list of such cases where the accused are languishing in jail since last 14 years. Friends, during my tenure as Executive Chairman of Chhattisgarh State Legal Service Authority and the Uttar Pradesh State Legal Service Authority, I have visited several jails in both these states and found that a lot is to be done for the inmates languishing in jails. Most of the jails are overcrowded to the extent of about 3-4 times of their original capacity. In some of the jails, either the prisoners are sleeping in shifts or they sleep like a pack of cards. Considering this peculiar problem being faced by the prisoners in jails, directions issued by my Lord are very helpful for the High Courts and the local administration, and we have started seeing the change in the jail condition. Though it is my welcome address, I would like to keep this point open for the discussion for construction of jails in vertical manner rather horizontal, so that proper minimum facilities can be provided inside the jails. Your Lordship presence at the conference raises our spirit. I welcome you, sir, as the chief guest of this event. On this occasion, I extend my warm welcome to Honorable Justice Sri Sanjiv Khanna ji, Judge Supreme Court of India. My Lord, you have with your devotion and hard work, sincerity, honesty, as also your equitable approach as a judge, whether it be on the judicial or the administrative side, made esteemed yourself not only to your colleague and legal fraternity, but also to the litigants public in this country. My Lord, Shri Justice Khanna authored the majority opinion in the Supreme Court RTI judgment, where the question before the 5 judges bench was whether subjecting the office of the Chief Justice to RTI request would curtail the independence of judiciary. Several other landmark judgments have also been delivered by my Lord, but here again, due to paucity of time, I find it difficult to quote. The presence of Honorable Chief Justice Sri Rajesh Bindal ji, Chief Justice of High Court of Judicature at Allahabad, has added radiance to the inaugural function. Justice Bindal has a vast experience of 4 high courts: Punjab and Haryana, Jammu and Kashmir and Ladakh, Calcutta and Allahabad. With his judicial and administrative skill, he is handling this high court in a most effective and useful manner. You can find him sitting in the High Court till late in the night. His Lordship's presence at the conference also raises our spirit. I welcome you, sir, to the inaugural session of this conference. I also welcome Honorable Shri Justice Rajiv Shakdharji, Judge Delhi High Court, Honorable Shri Justice Arun Bhansali, Judge Rajasthan High Court, Justice Shri A.K. Jayashankaran, Nambiar, Judge High Court of Kerala, and Honorable Justice Srimati Mausmi Bhattacharya, Judge Calcutta High Court, who are the members of the advisory panel constituted by NALSA. I also welcome my brother and sister judges of different high courts who all the way have come to grace this event and to exchange their thoughts for enhancing access to justice. I hope and trust that the vast experience of my brother and sister judges present here at least will provide some guidelines to the administration and also to the legal fraternity, so that the aim and object of the legal service authority can be achieved. I also welcome member secretaries of the state legal service authorities of the various high courts and the other members of authorities, because it is they who work as extended arm for different high court, and it is they who execute the various schemes, policies and guidelines. Last but not the least, I welcome a very new member of our fraternity, a newly born judge, Shri Ashok Jainji, former member secretary of NALSA, who took oath as High Court judge just a few days ago. He deserves lot of appreciation because of his hard work during his tenure as member secretary. I also thankful and welcome to the newly appointed secretary NALSA, Srimati Man. Before I conclude, I once again welcome all of you on this great event and pray for blessings of the Lord Shiva to the entire fraternity of our family.
Thank you, my Lord. NALSA has taken various steps to enhance access to justice to the people in need and to meet out many socio-economic challenges that the poor people face in our country. It has ensured free legal aid to accused persons at various stages of arrest and detention. In this context, early access to justice at pre-arrest, arrest, and remand framework of NALSA needs special mention. With these words, may I now very humbly request Honorable Mr. Justice Rajesh Bindal, Chief Justice, Allahabad High Court, to kindly deliver address.
Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Chairperson of NALSA. Honorable Mr. Justice Sanjiv Khanna, Judge Supreme Court of India. My brothers on the dais and sister and brothers from different high courts and from members of the NALSA, member secretaries and other officers who are present. A very good morning. Our High Court or the State Legal Service Authority is, I think, honored to be chosen to host this North Zone event in the city which is said to be the oldest living city. And Lord Shiva is there, and we know that he had consumed poison which had come out of Sagar Manthan just to save the humanity at that time. And today is also a very auspicious day because of this is Mauni Amavasya. We must have seen a lot of rush here. And in Prayagraj, probably we are expecting about 2 crore people today. So this is how the festivity is there now. Our warm welcome to Honorable Judges of the Supreme Court. The topic we all know we are discussing today. We have the Executive Chairman and member secretaries from 8 states and 3 union territories. Enhancing access to justice. Access to justice is one part, but access to court is another. Probably if we don't provide quality justice, that would mean only giving access to court. That we have provided a counsel, an advocate to any litigant who has approached us, but may not be the quality. That is the main issue, I think, which requires, and which has been touched earlier also in many conferences, and some improvement is there, but still I think that is the main thing we all need to see. There are a lot of youngsters who are taking care of the cases in legal aid. They are doing good work also, there is no doubt, but we need to have some senior counsel also. For that, it is the effort to be made by the state legal service authorities or at the district level. This is what I feel. Because there is one study conducted by the National Law University, Delhi. It's an old study, Quality Legal Representation, Free Legal Aid. There also they said that a lot of people had shared with them that they had gone for legal aid only because they did not have the money to engage a counsel. But that should not be the kind of legal aid we provide, that should not be of that kind. And I remember the words used by our earlier Honorable the Chief Justice of India, who retired recently, Justice Lalit. he said legal aid to poor does not mean poor legal aid. So that terminology I think we need to see and improve it. And in this, I think role of the judges also is very important at the district level also, at the High Court level also, to monitor the quality of work being provided, quality of assistance being provided by the legal aid counsels who are appearing for various parties. One thing is there that in recent past, we have seen how much people have availed of the legal aid. If we see the data of 2015-16, the figure was 3.11 lakhs. It increased in COVID-19 years because of a lot of issues. The figure was down, but in 21-22, the figure was 63.69 lakhs. That's a huge increase. And the reason therefore, we all know, was the extensive outreach program. There were various camps, I think, held throughout the country. In UP also, we had a lot of camps. And as a result of which, this people came to know about the legal aid, the legal service authorities, the kind of services being provided by us, and that's why they could approach us. And this is very important. And one of the at that legal this outreach program, I was in West Bengal for part of the time, and we had in fact camps or the stalls, kiosks on the railway station also. In the railway coaches also, because a lot of people travel in local trains there, and in that they have 15-20 minutes, 1 hour free. They can just read whatever is put there in the coaches. And this Magh Mela or the Varanasi, because a lot of people come here, we have our stalls, and this spreads a lot of knowledge about the legal service movement. So this is very important. We have to take care of it. And what we had seen, I can share the experience in information technology also. We had some camps to apprise people about the e-court projects also. And what we gathered from those stalls or the kiosk installed in various melas was that we could improve our system. We got the idea from the people that how we should improve it, how to access is better. Because easy to access is also one of the issue that we have a lot of information on our website or the system, computer system, but it should be user-friendly. So that those ideas we got. So similar ideas we can have from that. But one thing more is there that in some camps, we have a lot of people coming. We distribute brochures and all that. I think we need to have the data and monitor what kind of information or what kind of legal aid they wanted, what kind of assistance they wanted, and follow it up. Then in how much cases we could provide that. It should not be just an idea to distribute the brochures only, that's what we are doing. So I think this is required. And another thing which I thought we can spread this movement is, we have about 5 lakh students in law throughout the country. And there are about 6.50 lakhs villages in the country, out of which about 1 lakh, they say, is having population of less than 500, so very small villages. So if we connect all these law students with the different villages, I think maybe a cluster of villages with a group of 3-4 students, I think we can spread this movement throughout the country, and we can map and all villages in the country. Because litigation, we know 60-65% we are getting from the rural area only. Now if we see the jails part, Brother Diwaker had touched. We are here from different high courts, and the capacity is far less as compared to the inmates in that. And the maximum as compared to capacities in a small state like Uttarakhand. We were thinking maybe UP may be the highest, but little bit closer on higher side is Uttarakhand also. But there are all states where the inmates are more than the capacity. And many of them, as even had been touched by our Honorable President of India, Her Excellency, in the Constitution Day speech. I think many of you may have attended or heard that speech. Having deviation from her written text, she had shared the plight of the inmates in the jails. Mostly the poor people are in jail, and we should provide quality aid to them. So that is very important part which we need to see, and she had also, I think, experienced herself visiting the jails. And the problem, I think, which we had seen, because we had also visited many jails while I was in Punjab, and here also, In J&K also I visited some jails. In UP also, brother Diwaker also was there with me. Lot of issues are there. There is lack of connect between the inmates or the PLVs in the jails or maybe the jail authorities also. There are very small issues on which the inmates are there. Very small offenses. They say the bail is not granted or the conditions they have not fulfilled. Maybe some stringent conditions have been put in. So these are the very small issues, or they are in jail because they have not been produced in court for hearing. So those issues can be taken care of, and the capacity in the jails may be a little bit better it can be. If we connect the PLVs or sensitize the jail authorities that you should take care of it. And our local judiciary also, I think there is a regular visit by the district judge also. It should be by other judges also in the jail periodically, because they can also see the kind of prisoners they have in the cases pending before their court. So this is very important. I think if this is there, maybe these small issues can be taken care of in jails. Sometimes the data given to us is also not perfect or the correct. So this is very important. And we all know in our states also, all the states and the UTs we are here, majority of the litigation is on criminal side. And legal aid also we provide mostly on the criminal side, except, yes, family matters we are providing it, or civil side maybe little less only. And if we see the figures, highest I think what I could see is again, I don't know, in Uttarakhand only district courts have 86% of the litigation. This is what the NJDG website shows. And we are also close 83%, but Bihar is 85%, but rest all states are, except I think Ladakh, where you have 43% criminal litigation, others are all above 50. So this is the area I think where people who are there for lack of legal aid or otherwise the poor people especially, that should be taken care of. If we see the Lok Adalats, I think there is a lot of improvement in the working in the last 1 or 2 years. In last 5 Lok Adalats, we had, I think, pre-litigation disposed of cases are 3.46 crores. And post-litigation is 1.28 crores throughout the country, last 5 Lok Adalats. And I am really happy to share that out of this 3.46 crore, in pre-litigation 1.81 from UP, 1.81 crores. And post-litigation out of 1.28 crores, 28.32 lakhs were in UP. And I could see this result only because of participation of all the judges in the High Court. They had attended the Lok Adalats, they motivated the judges, and in the Lok Adalats when held, they motivated or convinced the litigants also. That's why we could get all these results. This is very important. If our involvement is there at all level, we can get very good results. And another thing which we experienced in UP was we had specialized Lok Adalats on different subjects and could get good result in that also. We had Lok Adalats for arbitration matters only, because a lot of executions and all that were pending in the arbitration or objections. And there was special Lok Adalats for some small cases in the jail also we had. In negotiable instruments, special Lok Adalat we had for petty offences in the district courts pending. And one area where we had experienced very good result was in pre-litigation family matters. And you see, we were approached by 10,000 people in that. And the success rate was in 3,600 cases. So that is very good, because we all know that in matrimonial cases, one case means then multiplied by 7, 8 minimum. And in one of the judgment, I think Hon'ble the Supreme Court had mentioned, it resulted in about 40 cases which were settled when the matter was settled in Supreme Court. And this was the initiative taken by Sister Sunita. She is there. And we got very good result in that. I think that can be tried in other courts also. ADR is, again, it is going on, but problem I think we are facing, and maybe similar in other states also, is the lack of trained mediators at the district level. We all know in the Commercial Court Act, pre-litigation mediation is mandatory, and a lot of litigation is at the district level only. So we need to have more trained mediators at the district level also. So that will be there. Then we can get, I think, good results in mediation also. Online mediation is another thing which need to be explored. This was there during COVID time also, but yes, there are some privacy issues, but those can be taken care of. But that is one idea where we should have, because what we had experienced that in sometimes mediation, one of the party may be in service and sometimes in armed forces. So he says frequently he can't get leave. So in those cases also we tried online mediation at that time before COVID also. And in some cases there was success also. I think the idea of this workshop is to have suggestions or what are the problems we all are facing and what solutions we have, so that those can be taken care of. Policies are framed seeing the problems only. And these policies may be framed at the national level, but the main workforce is at the district level only. So at the ground level, if the work is done in implementation of those policies, I think we'll be successful in the entire process. With all these words, I'm thankful that I got the opportunity to share some of my views in this conference. Thank you very much.
Thank you very much, my Lord. We are delighted, honored by the august presence of His Lordship, Honorable Mr. Justice Sanjiv Khanna, Judge Supreme Court of India, with us this morning. His Lordship is known for simplicity, elegance, and rare sense of justice across judicial fraternity. With utmost humility and respect at my disposal, may I now request His Lordship to kindly address this august gathering.
Respected Mr. Justice Sanjay Kishan Kaul, Mr. Justice Rajesh Bindal, Mr. Justice Diwaker, Mr. Justice Misra, sister and brother judges, members from the State Legal Services Authorities, committees, Namaskar. It's a very unusual occasion in the sense that all the people are gathered, all of us are gathered to discuss in this holy city a problem with regard to access to justice and enhancement of access to justice. The first issue which arises is, what do you mean by the term justice? Justice in one sense can be described as existence of rules that provide right to a fair and a just decision. Rules that provide equal and fair opportunity of winning against the most powerful and against the state itself. Now, in this sense, if one looks at it, justice and access to justice are intertwined and inseparable, because there cannot be any justice without equal access. As Justice Hugo Black of the US Supreme Court had rightly put it, there can be no equal justice where kind of trial a man gets depends upon the amount of money he has. In fact, if one looks at what the framers of the Indian Constitution did when they enacted Directory Principles of the State Policy, Article 21, 14, and 22A is reflected in the philosophy. These are the good norms which we have to follow when we go into the question of legal services authorities, legal aid, etc. Article 38, if one looks at, states, the state shall strive to provide the welfare of people by securing and protecting a social order in which justice, social, economic, and political shall form shall inform all institutions of the national life. 39A of the Directive Principles states, the operation of legal system shall secure operation of legal system that promotes justice on the basis of equal opportunity, provide free legal aid to ensure that opportunities of securing justice are not denied to any citizen by reason of economic or other disabilities. Article 21 says no person shall be deprived of his life or liberty except in accordance with the procedure established by law. Now, the procedure established by law must provide the fair opportunity to that person, fair and good opportunity, equal opportunity to that person. Article 14 states that the state shall not deny to any person equality before law or equal protection of laws. So the importance is equal protection of laws. Whatever rights are secured to any citizen, be it when he is an accused or otherwise fighting a litigation, he must have equal protection of the laws. That means he must be able to secure his protection. But what is of most importance for the legal services authorities is Article 22(1). No person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his own choice. Now, the choice will be irrelevant in case he doesn't have the money to pay. So it is important that he should be given the right to consult and be defended by a legal practitioner. If one looks at the legal Section 12 of the Legal Services Authorities Act 1987, it provides for categories of people who are eligible to legal aid, according to which almost 80% of the entire Indian population of 1.3 or 1.4 billion citizens are eligible for seeking legal aid and assistance. The provisions have been put in place to ensure that those who cannot afford it have the legal representation in every state. Every legal services authority has been constituted to give effect to the policies and directions of the legal services authority. Now, in fact, one of the very extraordinary situations is that India's per capita lawyer ratio is far better than most of the countries in the world. But in spite of that, this problem with regard to providing free legal aid or adequate legal aid still bothers us. If one looks at the glimpse of the legal aid in India, we have 37 state legal services authorities, 676 district legal services authorities, 39 High Court legal services committees, 2,361 Taluk legal services committees. Now, as of 2022, almost 57,202 paralegal volunteers were trained. About 15,485 paralegal volunteers were deployed in various states in the country. 50,394 panel advocates or free legal aid service providers are enrolled. About 11,802 legal services clinics, out of which 1,119 are set up in the jails. There, we had provided about 63 lakh, we had provided free legal aid or benefit of free legal aid to about 63,69,643 persons in India. I like to here differentiate between reach in and reach out approach as far as legal aid is concerned. When I refer to reach in approach it is resorted to by the public when they approach us for legal aid. That is when they want us to specifically provide legal aid in specific situations. But what we have to also differentiate is reach out approach. That is when we provide legal aid on our own to the public. This can be in the form of legal awareness and literacy, but more important than that is when there is a crisis in any situation, we have to come out and reach out and provide legal aid to them. Now, if one looks at the legal aid position in India, we have about 22,321 legal literacy clubs in schools and colleges in 2021, about 3,44,026 legal awareness programs organized, wherein about 5,24,36,674 persons had attended these programs in 2022. About 5,261 radio, TV, YouTube awareness programs, and about 61,901 digital webinars were conducted in 2021. There are legal services helplines which exist, but the problem is we have to activate them, make them far more receptive, consumer and citizen friendly. As Justice Bindal had pointed out, the ease of access is a major issue which has to be tackled and dealt with. The legal aid services help desks, similar to legal aid service clinics, must be established in court complexes and jails. This is again an area which we have to focus on. We have to then move forward into this. Because till we have these legal aid help desks throughout the courts and in the jails, we will not be effectively able to reach out to the persons who desire and require the legal aid. There has been a lot of focus as far as legal aid at the trial stage and at appellate stage is concerned. The area of concern, which is of very crucial importance, is to the pre-trial stage, which can be divided into three categories: pre-arrest stage, and the remand stage. This is the area on which we must focus for the simple reason this is the situation where when the person is being called to the police station or he's been interrogated, there the awareness of the rights and the awareness of the rights and availability of legal aid is of significant importance. We have framed in 2018 early access rules. Those rules have to be now enforced and implemented properly to ensure that the pre-trial legal aid is made available to the needy and required persons. Pre-arrest legal aid we have now, and with the enactment of Section 41A in the CRPC, which mandates issue of notice to the accused at the pre-arrest stage, this has to be, we have to ensure that these compliances are regularly made. What is the effect and what is the need for providing legal assistance at pre-arrest stage? It has the following benefits: making the suspect feel less isolated or intimidated, safeguard their rights as per law, keeping in check on the police aggression and abuse of power, avoiding unnecessary arrests, gaining vital and time-sensitive information or evidence in suspect's defense which may not be available after a passage of time, and protecting the suspect from being subjected to wrongful self-incrimination contrary to constitutional and statutory protections. Here, I'd like to also refer to the decision in Prakash Singh versus Union of India 2006 decision, which had postulated creation of police complaint authorities. These police complaint authorities were required to go into allegations against the police, one, in cases of improper investigation, refusal to file FIRs, custodial torture, and high-handedness. We have, if one looks at how the judgment has been implemented, we have only in 8 states PCAs, state PCAs, and both state and district PCAs in about 14 states. That means 22 states are virtually following this or partially following this. And in only 17 states, we have district PCAs. This is something we have to address and look into, and to what extent the state legal services authorities and committees can help us or come forward and protect the victims in this stage is a matter of concern which can be and should be looked into. Then at this time of the arrest stage, the prompt legal assistance at the time of arrest, assistance to understand why the arrestee has been arrested, protection against intimidation, ill treatment, and torture, assistance to explain and understand the criminal justice process, actualization of procedural rights, bail in bailable offenses at the police station itself. I have referred to in the end the decision in D.K. Basu's case. The issue which would arise and which perhaps requires consideration is, do we now at this, do we take advantage and benefit of D.K. Basu's case and require the police officer who arrests any of the accused to also inform the concerned legal services authority or the committee that such and such arrest has taken place? Does any paralegal or any person from the state legal authorities then interact and get in touch with the accused immediately thereafter to ensure that he's made aware of what of the consequences, reasons, as well as if he has any rights or any issues that can be dealt with. Integration to this extent may be required. Integration also may be required that all FIRs which are filed should be made available to, or should be uploaded, or should be accessible to the state legal services authorities or the committees, so that they have and they know what exactly where arrest has taken place, where the person has been detained, what time he was detained, whether he requires any legal aid or assistance. This is one aspect which may require a little detailed consideration, because there may be some other issues, technical issues or administrative issues which may come into way. The remand stage is equally very important, and efficient and effective legal representation to unrepresented arrestees is imperative. This is to ensure that unnecessary arrests are challenged, bail applications are filed timely, unnecessary remands are resisted, and police procedural rights are protected. I have got some data with regard to the early stage intervention by the legal services authorities and committees. This data pertains to the period 2019 to September 2022. This is from NALSA itself. About 11,505 suspects were provided legal assistance at the pre-arrest stage at the police station, out of which 4,246 suspects were not arrested. About 10,462 arrested were provided legal assistance at the police station prior to producing them before the court. About 1,13,614 arrestees were provided legal assistance at the remand stage, and 39,092 bail applications were filed at the remand stage, out of which 19,177 arrestees were granted bail. Now, if one looks at the figure at the legal aid which is provided at the remand stage is 1,13,614. But if one looks at the figures which are prior to that, 10,000 and 11,000, the figures are rather low. That means we have not been able to provide legal assistance at the pre-arrest stage. This should not mean that we are adopting an adversarial relation with the investigation. Our attempt is not to curtail investigation, but it is only to ensure that the investigation and the procedure adopted by the police is in accordance with law. In fact, if the procedure adopted by the police is in accordance with law, ultimately it helps secure conviction also. Invariably, we become suspicious sitting as judges that if the procedure adopted or some wrong things have been done at the time of investigation, there's any element of doubt which comes into our mind. The second thing which I want to point out, we have to get rid of the old psyche which said that until unless the police adopts high-handed and somewhat abusive, or in the Supreme Court. In addition to this, we have formulated about 15 schemes as of 2022, which are basically help the victims. I have noted 3 important schemes which are with regard to victims of trafficking and commercial sexual exploitation, legal scheme with regard to victims of drug abuse and eradication of drug menace, schemes with regard to disaster victims, etc. Do we have the data with regard to how much we have done in these schemes will be another issue which has to be examined and gone into in depth and detail with regard to each and every scheme. Do they require modification, changes, and how to make them reach out, reach in, approach in all the schemes? Where do we require the strengthening? That has to be examined and gone into. The victim compensation scheme is spreading legal awareness in the community through panel lawyers and paralegal volunteers, particularly in vulnerable areas and groups. This will apply to all the schemes, in fact. Provide legal assistance to the victims at the time of rescue and during trial. Facilitate the accessing of district legal services authorities for award of victim compensation under Section 357A of the CRPC. Monitor and act as social auditors of existing facilities available for rehabilitation of the victims. Act as converging nodes to ensure that governmental schemes meant for marginalized actually reach them. Initiate steps to to sensitize cooperation to support rehabilitation measures for the victims, including self-development and employment under corporate social responsibility, assist with training and sensitization of stakeholders like the police, lawyers, the prosecutors, and government servants, collaborate with the local educational institutions and civil services organizations. I'll just give you some statistics with regard to the compensation paid during the years 2021 and 2022. 8,715 victims were paid compensation, had filed compensation applications under the Victim Compensation Scheme under Section 357A CRPC. About 8,267 applications compensations were awarded by the court orders. Out of the total compensation applications, that is about 16,982 applications received. About 15,173 were decided in that year. The figure of 221 crores, which is the total compensation awarded, is fairly substantial, but it does show that the number of applications received are rather low. That is 16,982. This figure should be, are we satisfied with this figure? It will depend upon the data with regard to where the victims were entitled to compensation, but they were not given, or they did not know about their rights under the different schemes, and therefore they could not get the compensation. The other area which is very important is the witness protection. Witnesses are eyes and ears of justice. Now we have the Witness Protection Scheme of 2018 to ensure that the investigation and prosecution and trial of offenses is not prejudiced due to witness intimidation, provide confidence to witnesses to depose and assist law enforcement and judicial authorities, identify measures to safeguard the interests of witnesses and their family members. What is the nature of protection which is provided is anonymity, temporary residence in a safe house, new identity, relocation, etc. This again, we'll have to set up committees in all the state legal authorities and district legal service authorities to ascertain which are the cases in which witness protection is required, and then proceed whether we are able to give witness protection in all cases or not. If one wants to look at the witness protection, there were certain guidelines issued by the Delhi High Court in the case of Neelam Katara, but I'll skip that. You can have a look at the judgment and then understand that. The next area, which is perhaps a very important area, is mediation, which now under the Commercial Courts Act 12A, Section 12A, have to be now conducted by the legal services authorities. That's one aspect, but I have got some data with regard to the where mediation, on the figures of mediation, etc. I can skip that, but there's one area where we can explore mediation, which has been done in Delhi by collaboration between the Delhi government and the Delhi High Court, is to provide community mediation centers. This means what are the cases which go to the community mediation centers are neighborhood cases, parking, noise, nuisance, destruction of property, interpersonal, family, parent-child, parenting, child welfare, adult guardianship, restitution, divorce, maintenance, schools, special education, peer, student to students, minor complaints, corrections, commercial, consumer, merchant, small claims, workplace, bad checks, accident compensation, miscellaneous, police, citizen, minor criminal, victim offender, disabilities, cross-cultural, religious, charitable, and multi-party, etc. I can share with you one experience which I've had as a judge of the High Court, when large number of habeas corpus petitions were filed. Almost every day we'll receive 2 or 3, if not more. I did take help of the Legal Services Committee in that case to interact with both the boy and the girl. And then after they were made at ease, then we will interact with them. So then we'll understand probably because of the age difference, sometimes they're and our authority also, our position also, many of the time the petitioners or others, the parents also find it difficult to interact with us. So when you take help of somebody of younger age group, they're able to make them at ease and say the truth. That is extremely helpful in deciding. It also saves a lot of time which you would spend in these matters. Given the paucity of time, most of the case judges who are dealing with habeas corpus petitions are also dealing with pure criminal matters. there are benefits of obviously there are benefits of the community mediation, which I need not at this stage refer to, which is obvious because they're far more easier, it reduces the burden in the court. I think the decisions which are taken and settlements which take place at this stage, early stage, are far more easier, much far more, because everybody has an interest to settle the disputes. There's other area where we have to now focus is rehabilitation and reformation, which is a matter of concern. I think, again, there we'll have to get hold of the data and the particulars, how effectively we are doing this work, whether there are loopholes or there are shortcomings in this, and how do we improve that. I've given the details. I've mentioned about just the President's speech, which had highlighted the plight of the poor citizens, and also pointed out that all the people, including the ones who are in jail, they are one of us. Do not treat them just like one. They are just like us. The other area which has been highlighted, in fact, by Justice Kaul also in his judgments, is with regard to premature release. Now, if one looks at the data, the prison statistics for 2020, about 1,09,516 convicts were released from jails. And 49,386 convicts were released after completion of their conviction period. 43,033 were released on bail. Only 2,321 convicts were released prematurely. This is just 2% of, that means just 2% of the convicts were released prematurely. This is a matter of concern. Only 156 victims were released under pardon under 2021. So this area, I think we'll have to put into. We have, I can just share the figures with regard to the under trials as well as the convicted prisoners. The figures have improved a little bit, because the figures relating to 2020 showed that almost 76% of the persons in prisons are under trial, and only 23% are those who have been convicted. So this has to be also, this figure must be available to the legal services authorities to understand whether the courts, and feedback to the judges, are we being too strict, too conservative in granting bails or not? Because if the conviction rate is rather low, if we have the figures, then there's some problem with us. The premature figures, there's decision I've referred to of in criminal SLP criminal number 514 of 2021, which says there are 4 vital aspects of the process for premature release: timely identification of the eligible convicts, making applications by the eligible convicts with the help of District Legal Services Committee, timelines for application for procedure and decision for premature release of applications. If premature release of applications are rejected by the court or by the state governments, then legal aid be provided to the convicts to decide whether the said rejection should be challenged in a court or not. Then the other area, again, of little problem is probation. I think that's, again, an area which has not been properly explored and fully appreciated. I've referred to in my slide the Probation of Offenders Act and then Section 360 of CRPC. It's an area where we should come in and give full guidance as well as to the accused or the ones who are facing trial, to be able to appreciate and fully take advantage of these beneficial provisions. Look, many of these things cannot be implemented. This is a huge area. Our field is rather vast. But what has to be done is selectively and carefully implementing different parts of the entire role which we have in different areas, experimentation, and also with certain amount of flexibility, ensure that we are able to fully and effectively fulfill our constitutional objective and the statutory objective. Thank you so much. I hope this conference will find some solutions, some guidance for the future. The roadmap for the future, whatever we have achieved, is one thing. In fact, let me also say, once or twice when we had interaction with judges who had come from abroad, they were very much impressed by our legal aid system. Abroad, it's very difficult for any convict to get legal aid because the taxpayers' money, they say, should not be made available for fighting litigation of a convict. And they have processes by which there's a examination, detailed examination, whether the person who's convicted should be given legal aid for appeal. One of the other things, as far as trial is concerned, which is, I feel, can be looked into, is as far as heinous offenses where the punishment is more than, can be up to life imprisonment. Should we have legal aid committees going into the case files themselves and then guiding or saying, giving guiding or helping the lawyer who's conducting the proceedings before the trial court and in the appellate court? Because invariably what happens is many of the lawyers do not get the full feedback. And I must also share with you my experience as a lawyer appearing as a legal aid counsel in the High Court, which was a little bit disturbing. The accused came to me and interacted with me in the court itself. In the end, he said, "How much will I have to pay you?" I was taken aback. But that's a fact, that many of the convicts in jail do believe that you have to pay. The second thing which I noticed was that the percentage of cases being dealt with by legal aid counsels in the trial court is far lower than the percentage of cases which are being dealt with by the legal aid counsels in the High Court. The reason is this: when a person is arrested, he or facing criminal prosecution, they put in their entire stakes to get him released or get him acquitted. A lot of property, a lot of all their wealth gets spent at that stage. At times, false and wrong promises are also made. By the time the matter comes to the High Court or there is a conviction, the family members and the accused realize that possibly it's not working the way it is. So they withdraw, or their wealth is all gone, dissipated. So this, in fact, let me also say, the percentage of acquittal in the High Court, at least in the Delhi High Court, I saw in legal aid matters was higher than where private counsels were appearing. But private counsels were hardly appearing in about 10% matters, not more than that. So these are matters of concern. We'll have to there may be different problems in different states. I'm not saying what is happening in Delhi High Court will be replicated or is true for all the other high courts. This may not be true. But we'll have to go into the data, analyze the data, and then proceed forward. Thank you so much.
Thank you very much, my lord, for inspiring us. Prison confines human body, while the law liberates the human self. An in-depth study on the condition of prisons in Punjab that was conceptualized by Punjab SLSA, and the research was done by Commonwealth Human Rights Initiative with the conception of the Punjab Prisons Department, in which, and the guidance was provided by Honorable Mr. Justice Ravi Shankar Jha, Chief Justice Punjab and Haryana High Court, and Honorable Mr. Justice Tejinder Singh, Judge Punjab and Haryana High Court and Executive Chairman of Punjab SLSA. The efforts of Mr. Arun Gupta, Member Secretary, have been instrumental in the finalization of this report. This report is an in-depth empirical study of prisons in Punjab as to infrastructure, problems relating to infrastructure, problems relating to the availability of amenities that are required in law for the prisoners, They also relate to old prison issues, prison overcrowding, staff vacancy, lack of proper medical assistance inside the prisons, and so on and so forth. This report is to be released by Honorable the Chief Guest of this inaugural function. May I now most humbly request Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman, NALSA, to kindly release the reports entitled Inside Punjab Prisons, Study on the Conditions of Punjab in Prison. I request honorable dignitaries on dais to kindly join in the release process. Thank you very much, my lords. The vision of inclusive justice is at the forefront of NALSA mission. Under the visionary leadership of Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairperson NALSA. This North Zone Regional Conference is an earnest step in the direction of strengthening the mechanism for access to justice through legal awareness and effective legal representation to the marginalized and excluded groups. His Lordship's approach to inclusive justice is reflecting in many of his Lordship's judgment. It is my profound privilege and a distinct honor to request His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, to kindly deliver the inaugural address. Lordship, please.
Very good morning to all of you. Justice Khanna, Justice Bindal, Justice Diwaker, Justice Manoj, Misra, so many of my colleagues. Let me first say one of the most important aspects of any of these conferences is the interaction which takes place amongst us to think of various methodologies. And I'm delighted to see so many of familiar faces, people who I've worked with, and I am looking forward to their contribution, their participation, their views, rather than expressing any elaborate views of my own. This concept of regional conferences started almost 6-7 years ago. The idea was that in a very, very large composite conference, it becomes difficult at times to identify, and each region of our country has some element of its own peculiarities, some elements of its own problems, and possibly some kind of similarities in that area. So it's a more effective interaction which has resulted in these regional conferences, of course with the national conference in a year. The broad parameters on which a justice system is evaluated are availability of justice, accessibility of justice, and its deliverability. If I may say so, the equality of opportunity for justice is the base. We are a vast country with large population of socially and economically underprivileged. How do you create a balance between the two to work out their justice system? If the representation which they are able to obtain is very vastly different, then you can't say they are on the same platform. One of my great concerns, which was mentioned, has been the issue of people who are under trials, looking for bail, uh, cases to be considered for remission, whether they can be dealt with in plea bargaining. Because while a prosecution system needs to be strengthened, always I feel, because so there is effective prosecution, the defense system should also be equally strengthened so that they provide an equal opportunity. And the NALSA's view is to provide the best of legal assistance to people who are not otherwise able to afford it. And that's, I think, one singular part of the focus which must be maintained. A reference was made earlier both by Justice Khanna and Justice Bindal to the presidential address, the President of India, ladyship speaking on the Law Day. And after finishing her opening speech, she broke into what was her own experience, how she visited jails, how she the problem. We have a huge under trial prisoners. Is it that we think that we cannot convict people, so let us punish them by keeping them in prison during that period of time? This unfortunately seems to be a philosophy, I must say, which permeates. We think he must have done this because he is charged. Because he must have done it, we must keep him behind bars. And because we do not know whether we will be able to convict him or not, let us keep him behind bar for the longest time. Somewhere this philosophy must be jettisoned. The whole purpose, leave aside, I think, murder cases, extremely heinous cases. I have not understood what is the purpose of custodial interrogation or keeping him in custody beyond the period of charge sheet being filed. And this is something which we come across in the Supreme Court also. When I joined the Supreme Court, some of my colleagues used to say, let us not make the Supreme Court of India into a bail court. And I thought that's correct, we should be considering more serious issues. But that's a very important aspect of personal freedom. So before coming here, I tried to, at least in my personal way, to see how many cases am I interfering with where bail matters are coming before the Supreme Court. The figure was more than 33%. That is mean after it has been through a scrutiny by the district level, by the High Court level, still the Supreme Court has to step in for purposes of bail in more than 1/3 cases. This is something for introspection, I'm only saying. Where is that we are not able to, at the relevant levels, deal with it? Why should the Supreme Court be burdened with every day, every bench having anything from 5 to 10 bail matters coming, a bail, anticipatory bail? Therefore, it's an introspection and a rethought process for which the Supreme Court at various times has commented, trying to give some guidance for this purpose. The problem is, of course, more aggravated in some states, less aggravated in some of the other states. In this beautiful town of Varanasi, we are there. UP faces a great challenge. It's a great challenge because of the number of cases. And each state has its own peculiarity on this criminal justice system problems. So UP, Bihar, even Maharashtra, some of the states have a greater problem because of pendency issue. When I compare it with, in 2017, I left the Madras High Court. Murder appeals of 2016 were being heard. It's a large court. Is there something they do differently? That's why I say learning from each other's experience. Are they doing something differently? Is it some of the smaller states? Of course, it is easier. Somewhere the criminal justice system is far more burdened. Similarly, there are issues of, say, pendency of cases. When I went from Punjab, Haryana, in terms of more than 5 years cases, Punjab, Haryana had an extremely good number. It was less than 5%. I don't know what the current figure would be. So very manageable figures. Broadly the same number of judges, same number of volume of litigation and filing, same number of subordinate judiciary, similarity of figures between Punjab, Haryana and Tamil Nadu. The figure was 24% in Tamil Nadu. So why I'm trying to only give this example is that there are things happening in some states differently. Is it helping? So learn from us. Is there something happening which we can improve? That's again a learning process. And I think the first session which will be opened will be very important for this. When we talk about increase the number of cases, criminal cases, civil cases, let's understand one important factor is that the awareness of rights have also grown. It's a positive aspect. Women are asserting their rights, socially underprivileged are asserting their rights. That also creates litigation, but that's, I think, a healthy part of litigation which is necessary for evolving a society. Now, we have to see that we take the help to the doorsteps, something Mrs. Khanna also mentioned. So, one is somebody approaching us and saying, look, I need help. The other is to get to them, to make them aware of their rights and give them help where required. And I think the Legal Service Authority in the last few years has done a great job of trying to take it at the doorsteps. Different ways, use of technology, how to keep and monitor data, how to see to access people, how to solve their very, very small problems at times. One interesting methodology I found when I was in Punjab, Haryana was that at times of religious celebrations, the Legal Service Authority would open a clinic outside, and there would be normal day life small problems, whether it's getting a ration card, whether it's getting a Aadhaar card, whether it's some other small problem. But for the common man, that is important. It's not litigation in the true sense, but that's also part of the job which the Legal Service Authority does. And I think does it fairly well in its methodology of doing so. So how do you carry that forward as people's aspiration goes, as the problems increase? How to get it at that level where people are able to access and find a methodology to solutions? Because we still have a very bureaucratic system. Small things get tied up in many rules and regulations, and we are very reticent to change those complicated rules and regulations. Every form will run into some 10 paragraphs to be filled in for how to do it. On a little diversion on a lighter side, I can give you an example. So something like I was once in England and had a carry forward note of £1 which had gone out of circulation. The £50 note, I thought it's valuable money to see if I can change it. So somebody told me there are banks designated where you can go and change. So I went there and I handed him over the note. He said, you want to change it? He looked at it, tore it and gave me a new note. So I said, how do I sign which form? He says, go. That's how that is to be done. Look at the parameter in India. If a note had to be exchanged properly, we would have to handle a 2-page form before that can be taken up. This is responsiveness of administration to people which is required. And we don't have this responsiveness. So somewhere the judiciary in a non-adversarial fashion of adjudication of disputes steps in. And I think the Legal Service Authority does a very important role in it, in trying to bridge this gap also, apart from providing legal help. Cases of bail and remission, I think some kind of a revolution is required if we have to change things. Otherwise, we keep talking, it'll take us 300 years to finish these cases, 500 years. Today, somebody says 700 years. I really don't believe this is what is required. We've been trying to suggest to the government, not very successfully, I think, so far, that on this 75 years of celebration of the independence of the country, some out-of-the-box thinking is necessary. And I had an occasion to comment on it judicially to say that this out-of-the-box thinking can be, let's segregate the heinous crimes. Okay, whatever you may say, 7 years or 10 years, let's keep a benchmark. And if it is less than that, single offense cases, person has already served, say, 1/3 of the sentence. Then what Justice Khanna says, maybe under the Prohibition of Offenders Act or something, just take a bond and release him. Why do you want to make him go through trial in first tier trial, second tier appeal, third, and then land up, the state landing up in Supreme Court in every case? This is one of the problems. So that the courts are also a little free to deal with the more heinous crime cases and concentrate on them. They become the most prolonged and the equitable rate is also high. So yesterday I was talking to one of my brothers from this state and over dinner and just asked what would be in criminal appeals you would find as your acquittals, where conviction would have been done by the district court. He says 75%. Is it that 75% cases we are just convicting because we want to convict them at the district court level? We say the prosecution is not good, is poor, but that's not our job. It's not our job to prosecute. It is not the judge's job to prosecute. It is not the legal service authority to prosecute. There is a prosecution section separately. If that doesn't do its job, we don't step in and do their job. So, how do you explain to somebody, whether it's absence of prosecution or absence of evidence, that after 10 years he's going to be released without his being ultimately found guilty of what he is charged with? So these are aspects, I think, which need some debate. Mediation was mentioned. I'm a great believer in solving. I feel if you want every case to be tried, it will never happen. Nowhere in the world it happens. Nowhere in the world we face so many cases. On some opportunity to see how the US system works, California has a huge amount of litigation. 3% cases go to trial. We take 99.9% cases to trial. And if mediation has worked, let us acknowledge it has not worked all over the country. It has worked in certain areas well. It has not worked in some of the business states, I would say, which are high on business activity, where I think it should be a great way forward. And judges must step in. Judges must step in to encourage mediation. They must play a hands-on role. From Gujarat, one of the oldest persons of mediation used to come, and only thing would tell us, I wish my judges would also equally step in and give the impetus to mediation. And for that, I do believe we are trying to work out, because I also held the mediation committee of the Supreme Court. There is no harm or a positive approach if judges also go through a referral training program. Some of the states have organized. We are trying to organize for all over the country now. Whoever is willing, we can't force anybody to go through it, but go through a mediation training program. When some of us in Delhi took part in mediation, we sat through the whole training. I have personally gone through basic training 2-3 times over, advanced training 2-3 times over. I assure you, apart from whatever I may understand of a referral, I think in my own mind, it helped me understand the litigation better. It helped me understand the nuances of certain areas better, of how a litigant at times is not happy because his lawyer is not able to translate what he wants to say into the court. So these are all methods by which we can sort out these problems. Otherwise, if we think that all this litigation pending must go through every trial stage, must go through every appeal stage, and must be heard at the Supreme Court because the state has this great privilege and unending amount of financial ability to reach the highest court, then certainly these 500, 700 years talk will arise. The Legal Service Authority has a very important role, I think, in steering the system in this area. Try to see how to resolve these issues so that we can reduce the burdens of the court. And what has been said is the amount of effort made. Why, for God's sake, why should on an issue of remission matters keep pending? Why do courts don't push for the states to take a call, having different norms for remission? And how many cases the remission is being done where the appeal is yet to be heard because the time period is over? So we've let the whole time period of sentence go by without even advancing the person on bail. I mean, on a thumb rule, we said if somebody, even in a murder case, has for 10 years been in prison and the High Court is not able to hear the appeal, it's a single incident case. I don't think there's anything to be done. He has to be granted bail, there is no other way. Why do we need to spend so much of time on it, on these thought process? If we work out in our mind certain parameters, we have to, in these volumes, work out certain parameters so that we can help out. And as judges, help out the Legal Service Authority also in this picture in trying to do so. That link is provided by the Legal Service Authority. We have tried to step across in judicial sense. And let me say, some of the people in the Supreme Court Legal Service Committee have done a wonderful job of coordinating with the states, trying to see how a centralized system can be there, how all these aspects can be tackled. But at a more local, relevant level, it's the high courts will have to do it. And from the high court, it goes to the district court. District courts will take a cue from all of you. All of you, what you tell them and do so. And this requires a repetitive, sometimes interaction with the subordinate judiciary. One of the things, let me say again, which was flagged by Chief Justice Bindal was, there are cases coming where people are undergoing sentence because they're not able to pay the fine element also. So somebody may have gone through years of sentence, but that 1,000, 2,000, 3,000 rupees he is unable to afford. Invariably, if he is in custody for such a long period of time, the family has half the time leaves them. That's the role that comes in. Can we look to the legal service authority, debate it? Can this fine element be taken care of where a person cannot afford it? Some method to get the person out at these levels. These are again some thought processes which will have to be debated. There are concepts of new facets of legal service institution and aid which have come up. Legal aid clinics at different places are being taken place. We have to be also conscious that there are some states, as I now travel, and this is really my opening of the innings on these issues of various of the legal service authority. I had an opportunity to say travel to Nagaland. Now, the traditional methods of resolution of disputes are very much prevalent. And I said, look, we are not here to replace your traditional methods. We are here to facilitate with your traditional methods a resolution of the disputes, which was something which is appreciated. So we have to create an amalgam of what the constitution and the law we have laid down. Take local issues, local sentiments, local methodologies into this thing, which are sometimes good process of mediation, sometimes in serious cases not a good process of mediation. Try to provide the distinction between the two. Legal aid clinics in educational institutions. So we opened in a college a legal aid service clinic where people would assist and be educated, and also a center would be available. These are all illustrations of, I would say, the system thinking a little out of the box, how to help to the people who need it. We have endeavored on this under trial review communities to provide procedures and guidelines for them. Campaign or release and the large number of figures which has already been mentioned in the earlier speeches was done. And the national grid data was made available. I don't want to repeat on that aspect. There has to be, I think, adaptation, upgradation and enhancement, whether in the nature of facilities we give, whether in the mediation process we give. We have to adapt solutions which maybe other countries may have thought of, but in our local environment, in our local requirements which are there. We keep talking about sometimes how panchayats used to resolve. Yes, panchayats resolve certain things, but it's not mediation, to my mind, because that has a diktat to it. If a panch says something, it's an informal diktat. A voluntary mediation is something where the parties arrive at a solution. And that's why it's a more modern concept and worth exploring it. There is a digital boom which has taken place. Legal Service Authority has equally incorporated and helped out with it. One of the sessions is devoted to discussing this aspect. There are upgradation of records of cases, etc. done. NALSA's mobile apps, Vidhi charts, both are path-breaking developments, and that's how it should go on. And all of you, I think, can assist us in paving the way towards these new thought processes. Any constitutional right requires free legal aid, more so in a state which has such a large section of underprivileged population. To develop a trust factor between the legal aid seekers and beneficiaries with the legal services institution, it is important that the achievements of legal service institutions of rendering legal aid, referral, disposal of cases, mediation, lok adalat are put in the public forum, so people know that they have faith in getting their issues resolved through this process. I would only say, please come up with solutions. Please suggest methodologies. The discussions are not only to repeat what we may have achieved or something in that direction and make a record of it, but look to your guidance, your thought processes, your innovativeness in trying to help us out with what we are trying to do. I look forward to all your debates, and thank you all for joining us, and look forward to your interaction with you. Thank you very much.
Thank you very much, my lord, for all the guidance. May I now most humbly request Honorable Mr. Justice Manoj Misra, Judge Allahabad High Court and Chairman HCLSC Allahabad, to kindly deliver vote of thanks.
My Lord Justice Sanjay Kishan Kaul, Senior Judge Supreme Court Executive Chairman NALSA, my Lord Justice Sanjiv Khanna, Judge Supreme Court of India, my Lord Justice Rajesh Bindal, Chief Justice High Court Allahabad, my Lord Justice Pritinker Diwaker, Executive Chairman UP State Legal Services Authorities, my brother and sister judges of all the participating high courts, I thank you all for your august presence. I thank all the members of the member secretaries of the state legal services authorities of participating states for their presence, the state officials who have made our stay comfortable and ensured that we don't have problem in visiting various places in this holy city. My special thanks to Justice Kaul for giving us the opportunity to host this event in Varanasi, the holy city of India, and giving us the opportunity to host this event and organize the discussions that are to follow. There have been various issues which have been raised by my Lord Justice Kaul, particularly with regard to bails, which shall be issues dealt with during our discussions. My thanks to Justice Khanna for highlighting the concept of reach in and reach out, which perhaps we overlook, because the basic concept of legal services is not only to provide the services, but to make people aware that they are available to be availed. My thanks to you all, and my apologies if there has been any discomfort faced by any of you in your stay here. Thank you.
Thank you very much, Lordship. It is now time to pay our respect to our national anthem. For that, may I most humbly request honorable dignitaries on dais and off the dais and other participants to kindly rise up for national anthem. Before I seek permission for closing the program, two announcements are there. First, we have been directed to go for a group photograph, followed by tea. Everyone is requested for that. Lordship, I very humbly seek your permission to close the proceedings.
May I suggest, since we are running behind time, let's restrict the tea period to 15 minutes, and if we can do the group photograph at lunchtime, is it possible? That'll save some time, and we'll save maybe a little lesser time, because we must, because of continuing commitments, so everybody who are latter part of the evening also, we have to finish in time. And one request that I think everybody should be more participative in interaction rather than anything else. That may help us and curtail the time for it. Would that suit everybody? Right. Yeah. So let's break for tea for 15 minutes, and we can assemble here, and when we break for lunch, Or if you want, we can hold a photograph just now and break for tea. That is also possible. Is the arrangements made for photograph? Yes. Okay, then let's go to photograph immediately, then go for tea for 15 minutes and come.
Thank you, my lord. Proceedings for inaugural session stands closed with the permission of the chair.
किसके साथ में लगे हो?